The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon. Thank you, Mr. Clerk, and welcome to the North Carolina Court of Appeals, sitting in virtual session today. We have two cases on the oral calendar, but for this particular session, there is one, State of North Carolina versus Donald Redd. Your panel for this hearing is Judge Allegra Collins, Judge Don Tyson, and myself, Judge Bryant. And without further ado, we'll hear from the appellant.
Thank you, Your Honor. Good afternoon. May it please the court. I'm Narendra Ghosh of the Durham County Bar, and I represent the defendant, Mr. Redd. I'd like to reserve 5 minutes for rebuttal.
Okay.
At issue in this case are one, the initial frisk of Mr. Redd, and two, the almost 40-minute detention of Mr. Redd after he was frisked. On the afternoon of June 21st, 2017, Mr. Redd was hanging out on a sidewalk in a residential neighborhood with his brother and four other people when he was approached by several police officers. Neither Mr. Redd nor anyone in his group fled or acted nervously. The officers were investigating Mr. Redd. Earlier that day, Detective Ayers had been surveilling Mr. Redd and observed what he thought looked like a meat, but he could not confirm whether it was one. So, when he approached Mr. Redd, Detective Cumbo made up a ruse and told them a citizen complained about drugs being sold in the area. That was a lie. The officers then decided to frisk everyone, including Mr. Redd. They did not find any weapons or contraband on Mr. Redd or anyone else. After the frisk, Investigator Oakley walked to a white Dodge Charger parked around the corner. He saw Mr. Redd's drop.
I'm sorry. Can I stop you for 1 second? What was the purpose for the frisk?
Investigator Oakley and Detective Cumbo both said that they were concerned about whether Mr. Redd was armed, and that was the purpose on the frisk. So they asked him, they asked him, "Are you armed? Are you carrying anything?" And then they frisked him.
And what was that concern based on? The understanding?
So the testimony was that there was that their reasons were their prior knowledge of Mr. Redd. They testified that he had some affiliation or association with a drug trafficking gang called 52 North, but mere affiliation with a drug gang is not enough for reasonable suspicion. They testified about a strange comment from Mr. Redd's other brother, Derek, who wasn't even present, about Facebook and privacy settings or something, and this comment was made some weeks beforehand. That comment doesn't provide any suspicion about Mr. Redd. Investigator Oakley testified that he was familiar with Mr. Redd based on prior investigations, and he said that at some point, unspecified in time, a confidential informant had told him that Mr. Redd sold narcotics. But we have no idea who that informant is, or how reliable that informant was, or when that comment was made, or what the time frame referred to the supposed drug dealing was. And Investigator Oakley also testified that he knew that Mr. Redd had been charged with robbery, not convicted, with robbery at some unspecified point.
Mr. Gosh, I have a question for you. Does the record show that your client had been under surveillance for 3 or 4 previous stops in that vehicle he denied any knowledge of? Had he not been observed in known areas for drug activity 3 or 4 prior to this event?
So Detective Ayers had observed Mr. Redd in the Dodge Charger in 2 prior locations. One was a GameStop store, and one was a parking lot behind a church. And he testified that Detective Ayers testified that he knew he thought those were high crime areas. Although Detective Ayers was not the person who he was not on scene to do the frisk or the detention.
So this was not the first observation the owners had with your client. Is that correct that day?
It was the first observation for the officers who were actually on the scene. Detective Ayers had made observations beforehand, and he communicated some of that to the officers who were on the scene. So at like page 10 of the transcript, this is Mr. Cumbo who's testifying. He's on the scene, and he said Detective Ayers told him, quote, that he, quote, observed what they believed to be a meet at one point, but weren't able to confirm whether they believed it was a drug deal or not, close quote. So there had been some information relayed from Detective Ayers to the officers on the scene.
Did the officers initiate any stop prior to your client being arrested? Was the vehicle already stopped and your client was out of the car when they came on the scene?
That's correct. The vehicle was already stopped, and they were standing on the sidewalk when the officers came on the scene.
And does the facts also show that as the officer approached your client, two of the men that were there just walked away?
No, the record does not show that, and there's no factual finding to that effect. So the video, there's a video from Investigator Oakley's body camera, which shows them walking up to the group of people, at which point there are 4 men and 2 women. No one walks away. And then I believe after about a minute or so, all of them, or at least all the men, are frisked.
Do you think then your client, at what point do you think your client was not free to leave?
At the moment he was frisked, Your Honor. At that point when he's frisked and he's surrounded by a number of officers, I don't think any reasonable person would believe that they were free to leave. Shortly, and then that's confirmed on Investigator Oakley. After he sees the Dodge Charger, he starts writing up a ticket for the unattended vehicle. During that time, he tells another officer that, you know, if Mr. Red tries to leave, block him in. And then, so it's clear that they weren't going to let him leave. And then when he gets out of the car and they're standing on the sidewalk, Mr. Red's brother asks if they can leave, and the officers tell him, no, you can't leave.
I don't want to confuse this with the second issue, but the cases where a traffic stop has been unduly delayed to bring canine units, do you agree that there was no initial stop of the vehicle by these officers, that your client actually parked the vehicle, left it running, and walked away from it? Is that correct?
Yes, I agree that there was no stop of the vehicle, but Mr. Red himself was detained in that he was not free to leave upon the point that he was frisked and then continued to be surrounded by officers while he's standing there.
Thank you.
I have a question. Does our case law allow for a frisk for weapons because there's a reasonable suspicion of drug activity? Do they go hand in hand?
I'm not sure that, I'm not aware of a case that says that whenever there's reasonable suspicion of drug activity, that's like per se a basis to believe someone is armed. So, I mean, certainly there are cases where there are various factors that go to that. But, you know, in this case, as I've said, there wasn't reasonable suspicion of drug activity, and there wasn't reasonable suspicion that Mr. Red was armed. No one at any point saw Mr. Red carrying a weapon. Mr. Red did not hide his hands or have any suspicious bulge in his clothing that looked like a weapon. He didn't evade law enforcement or exhibit any nervous behavior. To the contrary, Mr. Red appeared to be nothing more and standing around with some friends on a residential sidewalk on a Sunday afternoon. So I don't think that there was reasonable suspicion that he was armed, which is what's required for the frisk.
Now, I have a question too. You were talking about, I believe, Detective Ayers. Was he one of the officers that was there and had surveilled that day and was familiar with the defendant's quote unquote background?
Detective Ayers had surveilled Mr. Red before the officers approached him, but he was not present when the officers were there. I think his testimony is that he did not actually get on the scene until after the canine had arrived. So during the time that Mr. Red and the others are frisked and then sort of detained on the sidewalk for those 40 minutes, Mr. Ayers is not on the scene.
But he
One
did
officer
ask
wrote-
other officers to follow the defendant, I believe.
So sorry, excuse me, I didn't quite catch that.
I said, but Detective Ayers, I believe, did ask other officers to follow the defendant, even though he wasn't there when the defendant was stopped or frisked.
Yes, Your Honor. Detective Ayers had requested that the other officers, I believe his word was approach Mr. Red to find out if there was criminal activity.
That kind of follows up on my question, which is this: can one officer rely upon the observations of another officer in forming reasonable suspicion?
Yes, Your Honor, if the information is conveyed to the other officer. So that is sometimes known as like sort of collective knowledge, but the knowledge has to be conveyed from one officer to the other.
Is there a dispute here that the officer that observed your client that day, that information was not communicated to the officer on the scene?
I mean, I don't think there's a dispute that some information that he had was certainly conveyed to the officers on the scene. I mean, he certainly, I think he told the officers that he had seen something that he believed might be a meat, and then he asked them to go to one location, which was the church, and then he or the others found him at this other location on the sidewalk. So there's no, I mean, so at least that some of that information about his surveillance that day was communicated to the officers on the scene. Now there's some other information that he testified about. You know, he indicated that this was maybe part of some sort of broader investigation, but you know, facts about that I don't think were conveyed to the officers on the scene.
If the officer had reasonable suspicion to make the initial search, would the 39-minute delay in getting the canine, how would that be unconstitutional if the original basis was lawful?
So I think the key fact is that the frisks turned up nothing. So even if you find that the initial frisk of Mr. Red was properly supported, those frisks didn't turn up anything. They were searched. I mean, you can see them doing what is a typical frisk. There's no weapons, there's no contraband, there's nothing else drug-related found on Mr. Red or on any of the other people who are standing there. So even if there was reasonable suspicion for the frisk, that suspicion was dispelled by the frisk finding nothing on Mr. Red or anyone else.
I'm not sure the exact sequence, and did your client initially deny any knowledge of any involvement with the vehicle that was running?
My client simply did not respond to the questions posed by the officers. At various points, officers asked the group, you know, whose vehicle is it? and my client elected to stay silent. So he neither admitted nor denied any connection to the vehicle.
Okay, independent of that, would an officer with a vehicle locked left running in a public vehicular area, would they have had reasonable suspicion apart from your client to do a search of that vehicle? If your client denied any connection or did not speak when asked, independently, would the officers had a reasonable suspicion to search that vehicle that was left running and locked in a public vehicular area?
I don't think so. I mean, I think they had certainly reasonable suspicion of a traffic violation of the unattended vehicle. Being an unattended vehicle could violate the statute. It's 20-163, and that properly could lead to a citation. But I don't think that is a sufficient basis to search the vehicle. And I think when again, even if they had reasonable suspicion to frisk Mr. Red, upon finding nothing on him or on anyone there, I don't think they had reasonable suspicion to then search the vehicle.
Did your client ever acknowledge a connection to the vehicle and the fact the vehicle was registered to his mother?
I do not. As far as the record, my client did not make any statements. The connection to his the registered owner of the vehicle was the officers looked that up after the canine alerted, and so that they just that was not provided by my client. That was this. They ran searches. They found that. They tried to call her, and then when they didn't get her, that's when they sort of asked for a lockout.
Well, then on that basis, if he did not claim any ownership, how can he assert any rights of his mother to that vehicle?
Well, I mean, the claim is not that that the search was the claim is not that the search was unlawful, and the search being after the canine had alerted. The violation is that he was detained for 40 minutes before that happened, and that the search of the subsequent search was fruit of the poisonous tree.
And can he assert that even though he did not assert any ownership to the vehicle itself?
Well, even if he did not at the time, did not say that he was the registered owner, I mean, he was still the driver of the vehicle. And the question on the suppression is whether or not the officers exploited the constitutional violation to obtain the evidence. And here, I think, given that the detention, 40-minute detention, was unconstitutional, if they hadn't detained him, he could have left. He could have left in his vehicle. The only reason they were able to search the vehicle is because they kept him from leaving for 40 minutes.
But he denied any connection to the vehicle, correct? Or at least he didn't assert any connection to the vehicle.
He exercised his right to remain silent. He just said nothing.
Well,
that can be held against him.
No, I agree. I guess my disconnect here is he didn't assert any claim of right to the vehicle. Either, I'm the lawful custodian and I'm the driver, it's my mother's, nothing like that. But yet, whether he was free to leave or not is a separate issue from what was discovered in the vehicle, a vehicle that he did not make any connection with. The officer, if the officer had come upon a locked running vehicle, would they have been justified to do what they did here, independent of anything else?
I mean, if there had been a locked vehicle and there was no one present, I mean, the canine like bringing the dog to sniff around is not a Fourth Amendment event. That's not a search. So that, that's in and of itself is not problematic. And once the dog alerts, there's probably a good case that provides probable cause to then search the vehicle.
Okay,
So the problem here is that the only reason that they were able to do those things is because they detained my client for 40 minutes and prevented him from leaving in his vehicle. And it's undisputed that he was driving this vehicle around. I mean, that's the surveillance. The surveillance showed that he was driving this vehicle. In fact, Detective Ayers, had surveilled him some weeks prior and saw him buy the vehicle. So the officers knew it was his vehicle, and his license was in the vehicle, which Investigator Oakley observed. So the officers all knew that it was his vehicle, and Investigator Oakley even said, like, I'm trying to prevent him from leaving because I have the drug dog coming, so I don't want him to leave. So Investigator Oakley was concerned about him leaving in the car before the drug dog arrived.
Could they have allowed the defendant to leave but kept the car because the defendant did not claim any ownership in it?
I mean, I don't think they had any basis to just detain the car separate from detaining Mr. Red. I mean, Mr. Red was driving that car. I don't think they had any basis for detaining the car separate and apart from detaining Mr. Red.
If he was driving it and they asked whose it was and he didn't claim it, had they allowed him to go, would he have been free to get in the car and drive away?
Yes, I mean, if they had not detained him, he would have been free to get in his car. Again, the fact that he did not answer the officer's questions, he is entitled not to answer the officer's questions. He's not required to say anything in response to the officer's questioning. And that, again, that he chose not to answer the questions can't be held against him. Again, it was no question that he was driving the car, that his license was in the car, and that they held him to prevent him from driving the car away.
I'm still having a problem with the disconnect because are you asserting now that if he had wanted to just walk away and leave the car, that he was restrained from doing that?
Yes, Your Honor. I mean, he was detained from leaving that spot on the sidewalk. I mean, that was clear. I mean, his brother asked, "Can we leave?" And the officer said no. I mean, they kept him right where he was on that sidewalk. So he was detained from going to his car. He was detained from going anywhere else.
If he had walked away, and the officers did exactly what they did by calling the dogs and discovered the drugs and the rest of the story, I mean, what violation would have accrued to him at that point?
So your question is if he had been let go and then he just walked away somewhere else and just left the car behind?
Yeah, or just walked away when they came up.
Okay. I mean, if Mr. Red had either left when the officers came up and just left his vehicle entirely and was never detained, then I don't think there's a constitutional violation because he's never detained, and the sniff of the car that's just sitting there in the public is constitutional. But so yes, if they had never detained Mr. Red, there would be no constitutional violation. The constitutional violations are they frisked him and detained him, and they prevented him from going in the car.
And again, to be sure that there's no dispute that his name was not connected to the ownership of this vehicle, right? It was his mother.
There's no dispute that his mother was the registered owner of the vehicle. Certainly he was connected in that he was driving that car before earlier that day, like minutes before apparently, and his license was in that car. So, and Detective Ayers saw him purchase the car, So obviously he was, the officers thought it was, his car, or at least, and certainly, family members often share vehicles. So, the fact that he's driving his mom's car doesn't mean, he certainly still has a right to get back in the car when he should be free from detention.
Was the purpose of detaining him to determine who owned the car and to write a traffic citation because there was a car that was left running during that 40 minutes of time? Did they look up the registrant? Did they attempt to contact her? Did they not contact her? What was going on during that time with regard to the citation?
Well, with regard to the citation, after Investigator Oakley saw the car and called for the K-9 unit, he then went back and started writing up a citation, and he discusses that with some of his fellow officers. And then after about 9 minutes or so, he gets out of the vehicle, but he doesn't present the citation. And then apparently at that point, like, nothing else is done with regard to the citation. They're not running record searches on Mr. Red or the vehicle. Nothing happens until the K-9 alerts. After the K-9 alerts, then they look up the registered owner and then try to call his mother. But that was over 30 minutes after he finished writing up the citation.
You have less than 5 minutes for rebuttal, unless there's another question.
Okay, yes, I'll reserve the remainder of my time for rebuttal. Thank you.
Thank you. Mr. Broughton?
Good morning, Your Honors. Good afternoon, I think we are now. May it please the court, my name is Robert Broughton. I've been sitting in a dark basement for a while. May it please the court, my name is Robert Broughton. I'm a Special Deputy Attorney General with the Department of Justice. I do represent the state this morning. Your Honors, as this court is already aware, this case represents just another entry into what this court has called one of the most voluminously litigated issues in the appellate arena, reasonable articulable suspicion. Now, one of the benefits of having a subject matter that has been so thoroughly litigated is that the role of this appellate court is well established and it is well known. And so I want to take a moment and just talk about that role, because it is strictly limited. Many cases out of this very court say the role of the appellate court in this instance is strictly limited to two functions, only two. Where there's been a challenge to findings of fact, this court may look at the record, go to those things that underlie those findings of fact, and determine whether there is any competent evidence. And then this court will take a de novo review of the conclusions of law and determine whether those established findings of fact support that. That's it. Those are the only two proper functions for this court on review. Now, Judge Collins had a question for counsel towards the end of his recital there, and the question was, what was the purpose of this detention? Now, the answer to that is answered by the findings of fact entered by this court. Finding of fact 12 says that the purpose of this investigatory detention was not a traffic violation. The purpose was to determine if Mr. Red had been involved in trafficking heroin, involved in drug activity. That is a established fact that cannot be revisited or revised or altered. It was not challenged on appeal. And for that reason, that is an established fact. The purpose, the mission of this of this seizure was to investigate drugs. It was not a traffic violation. Now, it's worth noting again, because the findings have not been challenged here, they are binding. It's worth looking at the full picture. This case did not start for law enforcement on the corner of Britt Road and Blaze Street. This case started well before then. Mr. Red was known by Winston-Salem law enforcement to be selling heroin in their community. Judge Tyson asked, is it appropriate for law enforcement to rely on what one another knows when forming reasonable articulable suspicion? The question is an unequivocal yes. That is appropriate. That is allowed. Mr. Red was known to be selling heroin. And on this day—
Let me ask you a question if I can, because this gets to the conclusion, and of course the facts that you were talking about lead into the conclusion. So the conclusion basically is that Officer Oakley had reasonable and articulable suspicion to perform the Terry frisk of defendant upon approaching him in a high crime area. The reason was because of his knowledge of the defendant's involvement in the drug activity in the past, which we just talked about, and the officer's experience associating drug sales with the presence of weapons. And I understand that that's something we've looked at, we put together, officers put together all the time, and that's used to put together the officer's reasonable and articulable suspicion that this defendant may be armed. But what I didn't hear or see in the facts was anything to indicate that this officer had previous knowledge that this defendant was armed. Not that just he was trafficking in drugs, but that he was armed. I saw where there was a possible robbery, but it didn't say armed robbery. So can you answer that? And then I have one more question.
Yes, Your Honor. Let me take a moment and answer that. So what our case law allows officers to do is where there is a reasonable suspicion that a person is armed, will make frisk. That's not violative of the Fourth Amendment. Now, previously, I believe it was, I think it was Judge Collins had a question. Does the mere fact that a person is suspected of drug activity, does that create almost a bright line rule that you can go frisk that person? And Your Honor, to that question, I would say no. There's not a bright line rule.
That's not Terry doesn't allow that.
That's right. That's right. This is not a bright line rule situation. But instead, what the state is asking this court to recognize is that Terry does permit frisks where there's reasonable suspicion of armed, and prior decisions of this court link, just as the officer did on this occasion, prior decisions of this court link drug activity to carrying weapons. This court has recognized that law enforcement, for the safety of themselves, for the safety of the public, and even for the safety of the defendant, law enforcement are entitled to make what this court has called common sense conclusions about the mode of operation of certain lawbreakers. That's kind of a pretty way of saying that drug dealers are generally known to carry weapons.
So let me ask you this. Suppose illegal weapons dealers were known by law enforcement. Would law enforcement then automatically assume that they were drug traffickers as well? Or is there a historical connection there? Or else every drug or every gun owner would be considered a possible drug trafficker if the reverse were looked at.
Yes, Your Honor, this court, the state would steer the court well clear of establishing any kind of automatic frisk. That's been out there, it's been tested, it's been rejected. So there would never be automatic frisk. The message from this court to law enforcement on the street should never be that you just walk up and frisk somebody. Instead, the message has to be that you have to act within the confines of the Fourth Amendment, and what the Fourth Amendment allows, develop that reasonable suspicion of armed. And one of the factors, one of the indicia, my counsel on the other side referenced different indicia of armed. This court has looked at different indicia of to whether or not a person is armed. One of that indicia is the fact that this person is involved in drug trafficking. Now, there was a question about what other cases. I believe Judge Collins said, does case law allow? And the answer to that again is yes. Clyburn is a case out of this court. Butler from the North Carolina Supreme Court, Alexander out of this court, are each cases where law enforcement approached an individual upon reasonable articulable suspicion of drug activity, and were entitled to make a frisk again for the safety of the officer, for the safety of the public, and indeed for the safety of the defendant. So that's what our findings of fact show here. For a lot of references to testimony, and this officer said that, and the video showed this at a timestamp. But Your Honors, that's not what's appropriate for this court to consider. Instead, this court is bound to stay within its lane as an appellate body by only considering the findings of fact. Mr. Redd has not challenged those. There is no reason to go into the materials underlying those findings of fact to determine if they are supported by competent evidence. They are presumed supported by competent evidence. Instead, the only role, the sole mission of this court is, do those established findings, those unchallenged findings, do they support that ultimate conclusion of law? Now Mr. Redd's position in this case, were this court to adopt it, were this court to instead ignore that isolated, that very narrow, strictly limited function, it would be making new law. Without a question, it would go pull this court beyond that strictly limited two-prong role and create an entirely new function for the appellate courts.
All right, I'm gonna jump in. So when we're talking about the reasonable suspicion, articulable suspicion of being armed, and you have said unequivocally there is no bright line, there is no point A from drug activity to point B, you get to frisk for weapons. We don't have that. What other than evidence of drugs, past drug activity, and linking this defendant to drugs that were the findings of fact do we have that this defendant was armed? So if not per se, drugs equals arms, what else do we have?
Yes, Your Honor, in this case, this court has at least 4 distinct factors, really 5 factors that it can consider as it weighs whether this officer was in possession of a reasonable articulable suspicion of drug activity. Now, the first is Mr. Redd's drug history, his prior involvement. That's not the same as conviction, but his knowledge by law enforcement that he was previously involved in selling of heroin in the community there. All 3 officers, the findings of fact reflect this. All 3 officers were aware that Mr. Redd was selling heroin in the community.
Yeah, I want to know other than drugs, what do we have?
Your Honor, there was no other indicia beyond the significant amount of suspicion related to drug activity.
So doesn't that just draw a bright line from drugs to arms that we have said that we can't do?
No, Your Honor, because the officer still has to make that decision. There still has to be a decision point. It can't be a bright line rule. This court has seen fit to
But the location, Mr. Broughton, would that be a factor? A known area for criminal activity?
Yes, Your Honor.
Would the time of day be a factor?
Yes, Your Honor.
Would the prior conduct, the defendant, and prior acts communicated to the arresting officer, would those be factors too?
Your Honor, yes, each of these would be appropriate factors for law enforcement to consider, and that's why the bright line rule is not appropriate. The officer still has to make that decision. He's still vested with that. This officer was aware that Mr. Redd had been involved in selling. He had been at a location selling. He had been observed what the Officer Ayers thought was a sale, what this court has previously referred to as course of conduct consistent with a narcotics sale. So you've got all these things. You tag on to that the fact that Mr. Redd then traveled through 2 additional areas also known for high drug crime activity. And in its totality, in this minimum level of objective justification that's required for reasonable articulable suspicion, the officer was entitled to make that frisk both for his own safety as well as the safety of the public and for the safety of the defendant himself. Now, Your Honors, I referenced that Mr. Redd wants this court to weigh evidence that is beyond the findings of fact, and that would be an inappropriate step for this court. It would take this court outside of its comfortable role as an appellate body, and it would convert it to a finder of fact. In other words, it would be this court usurping the role of the trial court. As long as we've had a judicial system, the trial court has been trusted with this important duty of hearing evidence, weighing credibility, reconciling conflicts, and finding fact. Mr. Redd's position in this case is that this court should take that video and take on that role itself. Now, Your Honors, what I would point out is that is inappropriate. First, because this court has said it was inappropriate. There's a 2014 decision from this court where this court has rejected that exact theory. 2014 case, State versus Sutton, the appellant in a reasonable articulable suspicion challenge, drug activity, appellant is the defendant at the time, was approached by law enforcement in the community. Law enforcement's wearing body camera. On appeal, the appellant did not challenge the finding of fact, but suggested that this court should view the footage, the videotape, independently and should make findings of fact that supplement what the trial court did. This court rejected that out of hand. It said that is not appropriate because our role is strictly limited to these 2 prongs. We look to see if the findings of fact are supported by any competent evidence, and we look to see whether the conclusion of law is supported by the findings of fact. That is the only role. Your Honors, I also point out that this court shouldn't get into the business of becoming a finder of fact because this court has recognized, as has the North Carolina Supreme Court, that videotapes don't tell the whole picture. That's why we trust the trial court. The trial court hears all the testimony. It hears the live testimony. It judges credibility. But this court, as well as the North Carolina Supreme Court, have both recognized that a videotape might not catch something that an officer on scene did catch. And so in that way, it would be an incomplete thing for this court to take on, that appellate fact finding.
But doesn't that sometimes affect the competency of the evidence? If the videotape showed one thing and the officer did another, and the trial court found something that was opposite of what was clearly on the tape, would you then say that the conclusion that was reached, that we should rely on those facts because of the conclusion that was reached?
Your Honor, I apologize. The audio was breaking up a bit there. What I understood you to say was that isn't it sometimes necessary to rely on the videotape because it might contradict the evidence heard at trial? Did I understand you correctly?
Well, it wasn't exactly put that way, but if there is contradictory evidence, and I realize the trial court is the trier of fact that determines the evidence, but then we, as you said, part of our role is to determine whether or not the evidence is competent to support the trial court's findings. And so there might be something in the findings that contradict and therefore might deem a particularly relevant finding as not competent. And then I think our job would have to be to scrutinize that. And if it's not sufficient, then I think we have to send it back.
Your Honor, yes, I agree that it is often the role of the appellate court to determine whether evidence supporting a finding of fact is competent. But that is only the role of the appellate court where an appellant has challenged those findings of fact. In this case, Mr. Redd has conceded in his reply brief, if it wasn't made clear enough from the opening brief, that none of the findings of fact have been challenged as unsupported. Where a finding of fact has not been challenged as unsupported, it is deemed, presumed to be supported by competent evidence, and this court need not inquire. So there's no reason to go looking at credibility issues or conflict from the videotape because Mr. Redd has not raised those before this court. It would be inappropriate for this court to take that step. Now, Your Honors, we've spent some time talking about the reasonable articulable suspicion, and I do want to point out that I started this argument, I started talking to you by saying this is one of the most heavily litigated, most voluminous areas of this law. This court has seen this exact constellation of factors before. So this court has seen a defendant who has a history of prior drug involvement in an area known for drug activity, observed in a course of conduct consistent with a drug transaction. This court has seen that, and this court has found that that set of factors equals reasonable articulable suspicion of drug activity. That was in State versus Summey, S-U-M-M-E-Y. That's a state referenced in my brief, a 2002 decision out of this court. And in addition, Your Honors, this court in the State versus Travis, which is a 2016 opinion, saw a very similar set of factors. In Travis, actually, it was even less indicia of drug activity than is present in this case. In Travis, this court heard evidence that a defendant with a known history of drug activity was seen engage in a course of conduct. In Travis, I think it was a car drove up alongside another car, engaging in a course of conduct consistent. And this court found that was sufficient to support that minimal objective level of drug activity suspicion.
What was the result of finding minimal of drug activity? Was it then permissible to do a search for weapons?
Your Honor, the two are undeniably related.
But in those cases, is that what the result was? Because there was a reasonable articulable suspicion of drug activity, the frisk was deemed to be constitutional?
Your Honor, I don't recall a frisk in either Travis or Summey. However,
okay, so that's not what you're citing those cases for?
Yes, Your Honor, those cases really stand for the proposition that the constellation of factors here should be deemed reasonable articulable suspicion of drug activity. That's why the officers, Mr. Ghosh, as part of his argument, says that my client was seized, Mr. Redd was seized. Well, law enforcement had reasonable articulable suspicion to make that seizure because of these factors that were present. And again, this court has found identical in Summey, even less in Travis that reasonable articulable suspicion exists here for that seizure to be made.
And and are you saying because of that, even though they found nothing with the frisk, they were allowed to detain him? Is that where you're going with that?
Yes, Your Honor, it's correct that the reasonable articulable suspicion of drug activity authorizes law enforcement to seize Mr. Red. Now, the purpose, the question from Judge Tyson early in Mr. Ghosh's argument was, well, how, I'm paraphrasing here, but how long can you hold him? Once the basis is lawful, how come holding him becomes all lawful? And Your Honors, to that question, a law enforcement officer is authorized to seize a person, to detain that person for the amount of time necessary, reasonably necessary, to complete the original mission of the seizure. That's why it's so crucial, Your Honors, that it be understood that finding of fact 12, the purpose of this seizure was not a traffic citation, it was drug investigation. So law enforcement did not have to let Mr. Red go as soon as they were ready to write a citation. In other words, this is not a Rodriguez, you need to find reasonable suspicion to prolong. Instead, the officers were authorized to detain him so long as they were making reasonable progress in the investigation of drug activity. Now, I've heard concern from this panel about the duration. I've heard concern from Mr. Ghosh about the duration of that seizure. Had him sitting on the road for 40 minutes was what I heard. Now, Your Honors, what I would point out is that first, again, an officer is entitled to maintain that seizure for as long as reasonably necessary to investigate. This was not a traffic stop. They were investigating the trafficking of heroin. That's not something you resolve in 5 minutes. But also, it wasn't that they were deciding, debating, wasting time, deciding when to call the dog. The evidence, the findings of fact here suggest the dog was called relatively quickly after officers arrived, and indeed Mr. Ghosh, as part of his argument, has said as much. The dog was called quickly, it just took a long time to arrive. So decisions from this court have acknowledged, have approved of delays up to 47 minutes. This is the Dakar case, a delay waiting for the animal to arrive of up to 47 minutes. And this court deemed that reasonable because the officers were being diligent in the course of their investigation. They were covering the things they needed to do. In other words, Your Honors, this wasn't the officers being dilatory. This was the town of Winston-Salem lacking the resources to get a dog there on demand. I think that's more likely than not across this state would be the case, that type of resource is not just available on demand. But what's important, the legally operative fact is that the decision was made quickly and not in a dilatory way.
Are any of these cases that you just mentioned non-vehicular stops? I realize there was a vehicle that was searched in this case, but was the stopping in any of those cases something other than a vehicle?
In Your Honor, I want to make sure I understand your question. When you say a non-vehicular stop, I
mean, the kind of stop we have here, where people are standing outside, they're approached by the officers, then the car that one of them was in is later searched.
Yes, Your Honor, in fact, they are. The Clyburn case, the Alexander case.
Clyburn, Alexander.
Butler case. There are a number of cases, and that's the appropriate way to look through this at this set of facts.
Okay.
I want to go back to the, to get clarity on one issue. I understand that Mr. Red was not arrested until after the dog alerted. Is that correct?
Yes, sir, that's correct.
Now, he's claiming that he was seized. Is that correct too?
Yes, sir, that is the claim.
Okay, so the question between the seizure, he was not free to leave, right? Does the state acknowledge he was not free to leave?
Your Honor, no. At this point, the state cannot say that, and I'll tell you why, is because the findings of fact do not reflect that. What, though, I would suggest, and the state has suggested this in its brief, that
I'm sorry, you're buffering, Mr. Broughton.
Please, can you repeat? Your video froze a bit.
I apologize. Can y'all still hear me? So what I was suggesting is that this is appropriate for this court to, this is a seizure, maybe. The state will readily acknowledge that where a frisk occurs, it is a seizure. Yes, no doubt about that. But if the defendant had consented to that frisk, then it may not be a seizure. Now, it is for reasons of judicial economy, it makes sense. Go ahead and treat this as a seizure. That's what we're arguing here today. It makes sense to do that. But I can't concede without more findings of fact from the trial court as to whether this was a non-consensual encounter. But
Let me follow up on that then. Once the Terry frisk, let's acknowledge it was valid, presume it's valid. Once that was over, the basis that occurred from that point up until when the dog alerted on drugs, how do we treat that interval? If he was not free to leave, was he seized the entire time?
Yes, Your Honor, it would be appropriate for this court to assume that he was seized for its analytical purposes. The findings of fact are not clear as to whether Mr. Redd remained on scene, and it's not appropriate to go digging past that. But for analytical purposes, assume he was seized. That seizure was appropriate because the law enforcement were entitled to a reasonable time to conduct their investigation into this drug trafficking. So yes, sir, it would be appropriate to teach it that way.
Let me ask you this. What's the state's position on the fact that the vehicle was not owned by the defendant and the defendant made no claim or assertion of ownership or custody of the vehicle? Is that relevant at all?
Your Honor, yes. The fact that the vehicle was not registered to Mr. Redd, but was registered to a third party, albeit his mother, is relevant. It has some de minimis value here in the calculation of reasonable articulable suspicion. This court has seen fit previously to say that the vehicle's registration to a third party is indicia of drug activity. That has been recognized by this court in the Clyburn case. Now, I will say that this court should recognize that at the time law enforcement ascertained this third party registration, they already had reasonable articulable suspicion of drug activity. So what the third party registration really adds to the picture is minimal. Yes, sir.
Well, then let me ask you this then. Am I correct that they did not try to determine who was the true owner of the vehicle until after the dog alerted? Is that correct too?
Your Honor, that's what is reflected in the findings of fact, is that after the dog alerted, they were able to run the tags and determine that it was registered to the mother. Yes, sir.
And does it also reflect that they had to summon an officer with an unlock kit to open the vehicle because there was no key at the site or none found?
Yes, sir. That is correct. They called for what the findings of fact described as a lockout kit.
Right. So let me ask you this: everything else being equal, if they said, "Do any of y'all own this vehicle?" Silence. Would the officers been justified then in having a record to come get the vehicle and take it to the impound lot if it's abandoned in the middle of the street with the motor running?
Yes, sir. Your Honor, the officers would have been justified in doing that. There was no one there to claim it. And Mr. Redd, as part of this, strikes the state as he wants to have the cake and eat the cake too. In other words, he wants to assert no claim over the vehicle, but then he wants to be able to drive away in it. And that is takes some gymnastics to get to.
Well, that's the big question. And I know when counsel has his rebuttal, the big problem I'm having in this case is the disconnect between any claim of right to the vehicle or the contents of the vehicle by the defendant, but him being able to assert some protection without asserting a right. Do you want to comment on that?
Your Honor, as I've stated, it would have been appropriate for law enforcement to seize the vehicle there if Mr. Redd had asserted no claim over it.
And take it away and impound it?
Yes, sir. And he was clearly tied to it.
And then they could have done an inventory search and impound?
Yes, sir. And again, that inventory not only would have revealed the trafficking levels of heroin, the possession of cocaine, it would also reveal Mr. Redd's license sitting there in the plain view driver's console.
Let me ask you this then, even if there was a violation, is this an inevitable discovery exception? Would the officers have inevitably discovered what was inside the vehicle by having the right to impound it or to search it where no one laid claim to it?
Your Honor, I agree with the court that the officers would have had the right to seize the vehicle as it was unclaimed. Where I would be hesitant is to say what they would have done, because it's not reflected in the findings of fact whether they would have in fact taken that step.
Right, it's hypothetical. If they had the right to search it in the absence of any claim of ownership by anyone there, and they, in doing an inventory search or whatever, they would have discovered what was in fact inside that vehicle, isn't that an inevitable discovery?
Yes, Your Honor, the state would agree with that position. In that hypothetical, with the right to seize and the fact they did seize it, would in fact be inevitable discovery.
Okay. And with that, even if there was a detention violation or prolong of the search, would that in and of itself be a separate basis to allow to deny the motion to suppress?
Indeed, it would. Yes, sir.
Thank you.
Your Honor,
Just a minute if you want to wrap up.
yes, Your Honors, and thank you, Judge Bryant. What I would leave this court, ask this court to take with it as it leaves today, is one, it is appropriate for this court to remain in its lane as a well-established lane as an appellate body. There is no challenge to the findings of fact here. There's no reason to go digging beyond those findings of fact. There's no reason to take this argument about supplementing. That has been explicitly rejected in sub. I'd ask this court to weigh the various factors, the history, the voluntary presence in a known drug area, the observation of drug conduct. Take all these things and find that there was this low level of articulable suspicion that authorized law enforcement to seize and detain Mr. Redd that day. For reasons stated here in brief, I'd ask you to affirm the ruling of the trial court. Thank you.
All right, thank you very much. Mr. Ghosh, you have just 4 minutes thereabouts for rebuttal.
Thank you, Your Honor. Briefly, with regard to the standard of review, our state Supreme Court made very clear in State v. Miller that facts independently gleaned from the court's review of video footage can be used in its legal analysis to clarify and supplement the trial court's findings of fact. That was in State v. Miller, reflected also in State v. Bullock in 2018 and 2017. So it's crystal clear from our highest court that it is proper to look at the video to supplement the trial court's findings of fact.
Those cases, can I ask you a question? Those cases make any distinction between facts that were challenged and those that were unchallenged?
Yeah, I mean, it's making the distinction because it's saying we're not, you can always use a video to challenge findings of fact, but State v. Miller said you can also use it to supplement the trial court's findings of fact. So supplement, we're adding to the trial court's findings with additional facts that are obvious from the video. That's what the court did in State v. Bullock. That's what this court can certainly do here. And
would that allow an appellate court to make inconsistent or find or resolve inconsistencies in the findings that the trial court's already made that has not been challenged?
No, Your Honor, and we are not challenging any of the trial court's findings. The trial court's findings are consistent with the video. They're just very incomplete. There are just many details that the trial court left out that are very pertinent to the analysis here. Counsel asked a bit about whether some of the cases relied on by counsel involved frisks or stops. Sumney is a good example. There was a frisk, but there were additional facts to support the frisk where the defendant had a clenched fist and the officer told her to open it and she wouldn't do it. And then they were allowed to frisk her to see if there were weapons in her fist. There do have, like, somebody highlights that there can and should be additional facts to show someone is armed. These cases also show, yes, like if there were reasonable suspicion for drug activity, you can briefly detain someone and investigate. That's what they did. They briefly detained, they frisked, they asked questions, and they got no further evidence of drug activity. In fact, it showed the evidence was not because he had nothing. So at that point, their mission was over. Then Investigator Oakley shifted to another mission when he saw the car, and then he started writing up a citation. I mean, it's clear he's writing up a citation and discussing it, that's what he's doing. So that's, and then he chooses not to hand over the citation, and they just detain everyone. And all of the cases that, all the recent cases that council discussed, none of them say you can just detain someone for 40 minutes. The one exception is, I believe it's the Derrick case from 1984. And that's involving an airplane, where an airplane is at an airport and the airplane is seized and the custom agents are called in and they're contacting various state agencies to investigate this. And there are many suspicious facts. And in that case, a 40-minute detention was upheld. But that airplane, airport context is far different. I'm not aware of any case involving pedestrians or cars where 40-minute detention has been upheld by our appellate courts.
I want to go back to the vehicle for a minute. In the hypothetical, when no one asserted ownership to the vehicle, would the officers have, based upon an abandoned vehicle running in a public security area, would they have been justified in having that vehicle towed away? Would nobody claim it?
I'm not aware of what standard there is to tow a vehicle away, but
If it's abandoned in a public vehicular area, no one is claiming it or making any assertion to it. As the officer, can they presume it's abandoned?
I mean, if it were truly abandoned, yes. But if what happened is they had released Mr. Red and he gets back in the vehicle and drives away, they can't do that. And he was driving this vehicle beforehand, and Officer Oakley's fear was that's exactly what would happen, because that's what he'd been driving the vehicle. It's entirely reasonable to presume that he would have driven it away. And so,
once your client denied any connection to the vehicle, and let's say he was released and started going to the vehicle, would the officers say, hey, you haven't asserted any rights to this vehicle. What basis do you have to go get inside that car? Could they have done that?
I don't. They can pose the question, but they can't detain him or investigate him. He was driving that car. His license is in that car, and it was registered to his mom. There's no evidence that it was stolen. So maybe if they had reasonable suspicion that the car was stolen, they could detain him. But there's nothing of that in the record. Instead, what happened is they detained him.
You're over your time, and unless there are questions, more questions about the facts of this case, we'll let you wrap up. Any other questions from the judges? You can take a minute to 30 seconds to wrap up.
I will just state very quickly, the last argument there was about inevitable discovery. Inevitable discovery was not argued by the state before the trial court, and therefore it's precluded from arguing it to this court, as this court has previously held. So for all of those reasons, Mr. Red's conviction should be vacated and remanded for retrial. Thank you, Your Honors.
All right. I'd like to thank counsel for your arguments here today. We really appreciate it. We do have another argument coming up. So, Mr. Clerk, at this time, we will close court.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you very much, counsel.
Thank you.
Thank you all.
Thank you.
Thank you.
And we'll meet back soon.